I'm here to explain California's petition process to seize guns under Penal Code Section 18400. Penal Code Section 18400 is a California law that sets out the procedure when law enforcement believes returning a seized firearm or deadly weapon, often from a domestic violence incident, could endanger the victim or the person who reported the incident. It requires the agency to notify the owner and, within 60 days of the seizure, extendable to 90 days with court approval, file a petition in Superior Court to decide whether the weapon should be returned or retained and potentially forfeited. Under Penal Code Section 18250 and related sections, peace officers must seize firearms or deadly weapons that are in plain sight or discovered during a lawful search. When responding to a domestic violence incident involving a threat to human life, a physical assault, or the service of a protective order. Normally, the agency must make the weapon available for return within 5 business days after a background check under Section 33850 and following sections, unless it decides the return would create danger. Section 18400 authorizes and requires the agency to file a petition in Superior Court to prevent return when it has reasonable cause to believe that returning the weapon would likely result in endangering the victim or the person who reported the assault or threat. Key provisions of Section 18400 include: the agency must advise the owner or the person who had lawful possession of its belief. It must initiate a petition in Superior Court within 60 days of the seizure date. It may file an ex parte application for an extension of time by showing good cause. Even with an extension, the petition must be filed within 90 days of seizure. No further extensions are allowed. This is not a criminal proceeding or a general gun confiscation tool. It applies only to weapons seized under domestic violence seizure rules, not to mental health seizures under Welfare and Institutions Code Section 8102 or other situations. The goal is a judicial determination of whether the weapon should be returned or permanently withheld and disposed of. The statute imposes strict deadlines for the petition, response, and hearing. The agency's petition filing deadline under Section 18400 is within 60 days of seizure, extendable to 90 days via ex parte application for good cause. The agency must simultaneously advise the owner of its intent to petition. For service and notice of the petition under Section 18405, the agency sends notice by registered mail, return receipt requested, to the person's last known address. If the person no longer lives there, the agency must make a diligent, good faith effort to locate them. The notice must inform the recipient they have 30 days from the date of receipt to respond to the court clerk to request a hearing. Failure to respond results in a default order forfeiting the weapon. The gun owner's response deadline under Sections 18405 and 18415 is 30 days from receipt of the registered mail notice to file a response or request a hearing. If there is no response, the seizing agency may file for a default judgment and dispose of the weapon under Sections 18000 and 18005 through sale or destruction. For hearing scheduling under Section 18410, if the owner requests a hearing, the court clerk must set it no later than 30 days from receipt of that request. The clerk notifies the owner, the law enforcement agency, and the district attorney of the date, time, and place. There's also a second hearing option under Section 18420. If the owner loses the first hearing, they may petition for a second hearing anytime within 12 months of the initial hearing date. Failure to file a second petition or a loss at the second hearing results in permanent forfeiture and disposal. The burdens of proof are explicitly stated and shift between hearings. At the first hearing under Section 18410C, the law enforcement agency as petitioner bears the burden to prove by a preponderance of the evidence, more likely than not, that returning the firearm or deadly weapon would result in endangering the victim or the person reporting the assault or threat. If the agency fails to meet this burden, the court must order the weapon returned and must award reasonable attorney's fees to the prevailing party. At the second hearing under Section 18420B, the agency's burden rises to clear and convincing evidence, a higher standard that's significantly more persuasive than preponderance. Again, if unmet, the court orders return of the weapon plus attorney's fees to the prevailing party. Possible defenses and challenges include changed circumstances, like the parties being separated or divorced, a permanent restraining order in place with no violations, or the alleged victim no longer fearing the owner. Other defenses: lack of ongoing threat if the incident was isolated, the reporter has recanted, or no further incidents have occurred. Legal entitlement, if the item isn't a deadly weapon under the definition, or the owner has cleared the required background check. Illegal search and seizure as a Fourth Amendment challenge, alleging police shouldn't have possession, so no forfeiture is possible. Procedural defenses include the petition being filed after the 60 or 90-day deadline, improper or missing notice under Section 18405, such as failure to use registered mail or failure to advise the owner promptly as required by Section 18400. Section 18400 also faces Second Amendment challenges under the Bruin and Rahimi framework. Bruin replaced means and scrutiny with a text and history test, where the government must show a regulation is consistent with the nation's historical tradition of firearm regulation. Rahimi upheld the federal ban on gun possession for those under domestic violence restraining orders, but emphasized it was temporary, and followed a judicial finding of a credible threat. Section 18400 may be constitutionally vulnerable because the Second Amendment protects the right to keep arms, and this law burdens that by authorizing permanent forfeiture, even without a criminal conviction or finding that the guns were used in any incident. There's no historical analog for permanent civil forfeiture, based solely on a law enforcement petition without a prior judicial finding of danger. Unlike the temporary restrictions in Rahimi, Section 18400 can lead to permanent destruction or sale of property. A challenger could argue this is an outlier law our ancestors would never have accepted. Facing a Penal Code Section 18400 petition in California means your lawfully owned firearms are at risk of permanent forfeiture, even without any criminal conviction. Without the guns being used in any incident and based only on a law enforcement agency's civil claim that returning them would likely result in endangerment. The process is time-sensitive with strict 60 to 90-day filing windows for the agency, 30-day response deadlines for you after notice, and hearings that can lead to default forfeiture if missed. The burdens shift, preponderance at the first hearing, clear and convincing at a second, but the stakes are high. Your Second Amendment protected property can be destroyed or sold under Sections 18,000 and 18,005 if the agency prevails or you default. Hiring the best PC 18400 defense attorney is often a smart move in these cases. An experienced attorney like Daniel Horowitz can make a real difference. An experienced attorney like Daniel Horowitz of the Law Office of Daniel Horowitz in Lafayette, Contra Costa County can make a real difference. As a State Bar of California Board of Legal Specialization certified criminal defense specialist, a rare credential held by only a few hundred attorneys statewide, Horowitz has over 45 years of practice, more than 200 jury trials to verdict, and a track record handling complex, high-stakes matters. His firm explicitly advertises expertise in Second Amendment cases, defending gun owners in both criminal prosecutions and civil restrictions involving firearms. What sets Horowitz apart for a Section 18400 challenge is his constitutional focus. He thinks out of the box and into the Constitution, particularly in firearm-related defenses. Post-Bruin and Rahimi, these petitions invite strong arguments that the civil forfeiture scheme lacks historical analogs for permanent disarmament without conviction. Horowitz's background includes commentary and representation tied to gun rights issues, such as criticizing federal overreach in scandals like Fast and Furious, plus his libertarian-leaning approach to defending individual rights against government overreach. In short, Section 18400 cases blend civil procedure, firearms law, and emerging Second Amendment jurisprudence, areas where a generalist might miss nuances. But a trial-tested specialist like Horowitz, with proven emphasis on gun owner defenses and constitutional arguments, is well-positioned to fight aggressively for return of your property. Contact Daniel Horowitz if you need help with an 18400 petition. You can reach Daniel at 925-283-1863.